Good morning. This is the time set for oral argument in LUBA number 2025-088, JIPR LLC versus the City of Carlton. I'm Board Chair Zamudio. Board members Wilson and Basham are also present. Please mute your audio when you're not speaking. That will help with the recording. And in this matter, we have a motion to take evidence and a motion to strike that are pending. We will resolve those in our final decision. And petitioner, you have a total of 15 minutes and may reserve up to 5 minutes for rebuttal. Would you like to reserve any time?
Yes, I'd like to reserve at least 4 minutes. But I guess if I am able to stop my initial remarks earlier, then I would take up to 5 minutes.
Okay, so you want to reserve 5 minutes and then you might go into that rebuttal time. Is that what I understand? Okay, sounds good.
Yes, thank you.
I will keep track of time here and also ask that you keep track on your own. The clock that's on the screen is just for general reference. It's not keeping exact time. And respondent and intervener, you have a total of 15 minutes. Have you discussed how you'll share your time?
Yes, we'll be splitting our time evenly, but we'll be each arguing each other's arguments, essentially. So, if that makes sense.
Okay, sure it will as we proceed. Again, I'll ask you to keep track of your own time and I will look here as well. And so with that, petitioner, please state your name for the record and begin.
Chair, members of the board, my name is Nick Roten, and I have the honor of representing the petitioner, JIPR LLC, who is the applicant below, who, as you know, applied to develop a convenience store and fuel station, and those land use applications were denied by the City of Carlton, which resulted in us filing the subject appeal. So there's 9 assignments of error in the petition for review, and I'm only going to focus on some of the items today. So as far as today's takeaway and what I would impart, this case has some unique facts and there's some rare legal questions teed up for the board to decide. The most consequential is the 6th assignment of error, which relates to ORS 197-835-10AB, which provides a remedy to an applicant when the local government's action was for the purposes of avoiding ORS 227-178, the 120-day requirement or the 120-day. As I'll explain, this case falls within the scope of that remedy because petitioner didn't have a true decision on the merits within the statutory timeline and was instead denied its substantial rights to a full and fair hearing because of concern with possible mandamus in whole or part. I hope to spend most of my time discussing this, but that's not the only rare or unique item. So kind of want to quickly run through some other important things before I can address that analysis and some of those cases I cite in the petition. So there were a variety of errors before both the Planning Commission and the City Council. Errors before the Planning Commission included the failure to allow response rebuttal evidence, including after an open record period and also after at least one ex parte contact and site visit and a variety of other evidence outside the record. That's not necessarily rare, but what is rare, however, is that the City Council refused to schedule a de novo or evidentiary hearing to cure the errors which occurred before the Planning Commission and instead decided after an on-record review where no new evidence was allowed.
Council, did the applicant request a de novo hearing before the City Council?
Yes, so both in writing, we requested the opportunity to submit new evidence if, I guess we basically said no harm, no foul. If you're going to approve it, that's fine. But in the event that there's any question at all about the substance of the application, we explicitly requested the opportunity to submit evidence in a de novo hearing. That's both in a written appeal statement, and then also there's a motion to take evidence that has emails with city staff prior to the hearing. And I cite to various portions in the record where I say we're willing to waive the 120-day. We're willing, in order to put new evidence in the record, if you guys find that there's an issue with the application, which again, it's kind of saying, if you don't need to schedule another hearing if you're going to approve it on the record. Again, the staff recommendation was to approve, but if there's any question at all, which we also had a suspicion that the city was inclined to deny it based on public pressure, we made clear that that would be legally impermissible unless there was a new hearing scheduled where evidence could be submitted, which is a de novo hearing under the Carlton City Code and under.
Okay, and I understand, thank you for that answer. I understand the response briefs, or at least one of the response briefs, to say that the applicant would not waive the 120 days, and so that essentially justified the city council proceeding on an on-the-record, in an on-the-record way. You're saying that the applicant did request de novo and offered to waive the 120 days to allow for a de novo hearing.
Yes, and I think I explicitly put specific citations in the reply brief. But even to the extent, and it's also in the petition, but even to the extent that that is their position, I would say that's an interesting argument to make that actually falls directly within the scope of what ORS 197.835.10 AB is intended to prevent, which is basically conditioning applicants their substantial rights to a full and fair hearing based on the 121-day deadline. At the record, I think it's 87. That's exactly what we argue in our appeal statement, that you can't compel an applicant to waive the 121-day. It's the city's responsibility to select a timeline compatible with ORS 227.178. But even here, again, as a practical matter, because we just wanted to get this application approved, we were like, at this point, if that is the issue, we will extend the 121-day, tell us how much time you need to schedule de novo hearing, submit evidence. And I think those citations are in the reply brief, but it's in the record.
Thank you. One more question. If we were to sustain one or multiple of your procedural assignments of error, first of all, which gives you the most relief? Second of all, what's your position on how we should proceed in terms of remedy and reaching any of the merits of the criteria?
My position is that I think there is clear procedural error in that we weren't allowed rebuttal and response evidence after the open record period. We were denied final written argument, and under the unique facts of this case, I think that did extend to the city council proceedings. The city knew that, but they proceeded to have deliberations on October 22nd because of concern with mandamus. They said that expressly. The Miller v. Multnomah County case shows that staff statements and recommendations are relevant evidence of intent of the local government. So I think that gets you procedural error.
Okay, so if we sustain that assignment of error for violating the statutory 7-day final argument allowance, would we then need to also address your arguments about bias and conflicts of interest, or would we not address those things?
Well, I guess so. Sorry, and just real quickly, I guess my point is what grants us the most relief, and I put it at the 6th assignment of error because I wanted it to be after you can read through the procedural errors, but it's ORS 197.835.10 AB. But the case law, and I encourage you guys to, and then you will, but the Walmart final opinion and the Walmart order, and the Walmart v. Central Point. If you read that opinion, which discusses the intent of that statute, this is squarely within the merits. But there has to be, and what hasn't happened in any other case until now, is there has to be a deprivation of the petitioner's substantial rights to a full and fair hearing. So you got to find one somewhere. I would say here it's the lack of response and rebuttal evidence after the open record period at a minimum. Also, you could argue the lack of final written argument, but that would give us a reversal of the city's decision and an approval with the conditions of approval that were proposed by staff and the applicant. I think there's a City of Salem case, and that was when a city acted outside of the range of its discretion. But you basically say, okay, we have to reverse it and approve, and then we'll go back and the city can go back and find what conditions of approval were suggested and recommended, and then that's what the city has to go back and do. So I would say that would grant us the most relief, is reversal on ORS 197.835.10 AB, because the petitioner did not have its substantial rights were violated, and it didn't have a full and fair case, and therefore it was not a decision on the merits. It was instead a pro forma decision. Again, if you really read the nuances of the Walmart case, that's what the board is looking for, and what Walmart didn't allege in that case, which prevented it from getting that relief. In addition to later cases, Oregon Pipeline in 2013, it's discussed, and Circerelli. So you have to find the prejudice of the substantial right, and then assuming there's a situation that falls within the scope of the remedy ORS 197 83510 AB, that would grant us the most relief. I think you should still go and proceed to, I think the board could and should proceed to a bias analysis, because that would, but I suppose it does not have to if it finds that there was a substantial right, which is prejudice, that denied the applicant a full and fair hearing because of concern with the 120-day deadline, which the Miller v. Multnomah County case says it doesn't need to be the primary purpose. It just needs to be in whole or part or a consideration of the local government. That's in one of the footnotes, and then in the body of the opinion, in that case, Miller v. Multnomah County, the board did not grant relief because LUBA found that the county commissioners didn't even consider the 120-day deadline at all as a matter of fact. Instead, the board found that as a matter of fact, the board thought they were just taking a purely ministerial act and just memorializing what had already been done, which was mistakenly and innocently entering a nunc-pro-tunc order based on a prior oral decision. That is distinguished from the facts of this case, where, again, this is not something that would become ubiquitous. So it's not something that I think for policy purposes, the board should be cautioned about granting relief on. But this is a rather rare case where there is a deprivation of the petitioner's substantial rights to a full and fair hearing, if nothing else, on the lack of rebuttal and response, because of concern with the 120-day deadline. And as policy matter, the Oregon legislature wanted to make sure that applicants can have a full and fair hearing within that 120-day deadline, and you don't condition their right to a full and fair hearing because of the 120-day clock. It's the city's responsibility to make sure that they get the full and fair hearing within the 120-day clock. The Walmart opinion discusses that a good faith approval is one of the merits, which means a real decision, which means, and it even says that means an adequate evidentiary record, which would withstand appeal. Here,
you're going into your rebuttal, and you're welcome to, but at
Yeah.
this point, you have about 4 minutes for your rebuttal. So just wanted to make you aware of that.
Okay. I would just say quickly, because just, there's obviously a lot to go through. The briefs and the reply have a lot there. I would say that as it relates to bias, if you're not going to find a reversal because of the application of the ORS 197-83510-AB remedy, the bias, this is unique. This is Columbia Riverkeeper and Botts Marsh have a very narrow basis to allow for actual bias. I think that's the case here. And with that, I will reserve the rest of my time for rebuttal.
Okay, and you'll have about 3.5 minutes for rebuttal unless there's questions from the board. Okay, 3.5 minutes for your rebuttal. And with that, we will turn to respondent or intervener respondent, whoever wants to go first. Go ahead.
Intervener respondent, Andrew Mulkey for intervener respondent, Felix Madrid. I'd like to begin by talking about generally the framework for the first, second, third, and assignments of error, and it also includes the fifth and sixth assignments of error. But with respect to these procedural errors alleged by petitioner, these all have to do with, and I want to refer LUBA to the Pinnacle Alliance Group case, but when there's an opportunity later in the proceedings or before the final decision maker to submit evidence during a de novo hearing, then that opportunity is adequate to ensure that the petitioner's substantial rights to prepare and submit its case.
How does that apply where there is no de novo hearing here?
So in this case, I think it gets to the point that your question earlier about the 120-day clock. And here it is true that the record shows that the petitioner did ask for a de novo hearing, but again, the petitioner never authorized that de novo hearing by giving the city the waiver for the 120-day clock that it needed to actually have those proceedings. And so
Petitioner said during his argument that they did offer that they were willing to waive the 120 days. So is this a disputed fact here?
Well, no. And I think what I want to say, and petitioner's counsel did it again here, is they're making a conditioned offer. They're saying on a hypothetical event that they don't know the outcome of. So they're saying we'd be willing to grant this authorization if you feel that you need it. But otherwise, we don't think it's necessary. We don't, and specifically the words here that are cited in the reply, the made in the record and made actually before the final decision maker is, we would be willing to grant a period of time to hold the record open, but then in the next breath, council states, we don't think that's required. And again, it says the applicant would be willing to grant a waiver of the 120-day rule, essentially, for the time period necessary to have another hearing. But again, that's not necessary under the circumstances because the criteria are met. So I don't think, in other words, this isn't a case in which, similar to Lower Lake Subcommittee cited by the applicant, in which the county or the city simply denied a request or declined a request for a de novo hearing. What happened here is petitioner made the request, but they never took the additional steps needed to authorize the time needed to have that hearing. And so this is more a case in which petitioner had the opportunity, but did not take the steps necessary to take that opportunity. And so these errors basically negate, I think, the first, second, third, and also fifth and sixth assignments of error, because petitioner again was always conditioning its request or its willingness to provide authorization on something that had not happened yet.
So even if petitioner didn't authorize an extension of the 120-day clock, why is it petitioner's responsibility to help the city out when they've, for whatever reason, have taken longer than they're supposed to have taken?
Well, I think in this case, the city's procedures provided the option of a de novo hearing. And so again, that was based on petitioner's assignments of error in a local appeal. And so it was petitioner's burden then to provide the city the time it needed to address those assignments of error. It had the opportunity. And I think that's the thing here, is that the case law shows that if the opportunity is available and a petitioner does not take it, then there's no substantial prejudice here. Or there's no prejudice to a substantial right, because again, I think what happened here is that the petitioner simply wanted to win and wanted to proceed with the development, and was not willing to put in was not actually willing to put in additional time to allow additional evidence to be submitted. And that brings me to the sixth assignment of error here. And I think this really turns on two things. The first is preservation, which again, respondents, and I think intervener respondents' point is that petitioner did not raise the issue of a violation of ORS 227178. In other words, petitioner did not argue that the city was avoiding the requirements of the 120-day rule or otherwise violating ORS 227178. And it did not do that at any point in time before the city council. It did not do that before the planning commission, and it certainly did not exhaust that in its appeal statement. And so for that reason, it's not a matter of whether or not necessarily petitioner cited 197A35 subsection 10AB, although it didn't. It's also that it did not raise significantly the error that it is trying to remedy in these proceedings now. And I'll point out that, the raise it or waive it rule applies to issues, not specifically criteria. And so even if there's an argument that somehow ORS 227178 wasn't a criterion or somehow did not need to have been assigned error, the issue was not raised below. And so for that reason, there's no opportunity to raise those on appeal here. Finally, again, I think that petitioner had the opportunity to request and authorize a de novo hearing, but never specifically made that authorization. And I think what that would have looked like here is petitioner just saying, I will authorize an extension of a month so that we can come back and have another hearing and do that. And I make a motion to do that in front of the city council here. at the hearing. And petitioner simply didn't do that. It only stated a willingness to potentially do that, but it never affirmatively gave the city council what it needed for that. Finally, I do want to point out that the city, my reading of Walmart is that the remedy provided in, 197835 does not apply when the city issues a decision on the merits or makes what would otherwise be a good faith decision. This is not an instance of bad faith denial of the opportunity for hearing. The city made an actual good faith decision on the merits, and the record shows that, simply put, the applicant failed to comply with the access spacing standards, failed to comply with the standards required to modify those access spacing standards, and failed to comply with the off-street parking standards. And those are all new bases for denial that were included in the final decision maker's decision. And so I do not believe that they were affected by any of the potential errors in the lower decision maker's decision. And I'm going into Mr. Yeoman Millett's time, so I will stop it there and turn it over.
Go ahead. Thank you.
Madam Chair, Board, one of the prior questions related to which assignments of error the board should rule on, and that brought in petitioner's fourth assignment of error relating to actual bias by Councilor Terrell. It is a respondent's position that petitioner failed to preserve this issue for appeal during the city council hearing. Councilor Terrell made multiple disclosures of ex parte, excuse me, not really ex parte conducts, but outside statements that may indicate bias against this particular kind of development. Those disclosures were made on the record. Councilor Terrell then explained again on the record that she understood the high bar that public officials are held to in making a decision on the merits of the case, that they must afford the applicant a impartial hearing, and they must base that decision on the applicable criteria. After all of the council members' disclosures were made in open room with petitioner present, an objection to any of the disclosure statements was requested. No objections were made. It was only when petitioners or applicants council realized that the council was going to deny the application, excuse me, that an objection was made, raising concerns about Councilor Terrell's bias. The record does not include sufficient evidence to prove actual bias or that Councilor Terrell prejudged this case. The discussion among the council, the final decision maker in this matter, clearly showed that the decision was made based on the applicable criteria and the substantive merits of this
Do you
case.
have any case citations where we found a bias concern was waived when there were initial disclosures and the objection didn't come until later in the same hearing?
I do not have a citation for that, Madam Chair.
Okay, thank you.
Related to the bias matter, depending on, again, it's relating to the prior question on requested relief and what happens after this hearing, after the board makes its ruling. There was an allegation in petitioner's fifth assignment of error that one of the planning commissioners had an actual conflict of interest in this matter. The concern there relates to whether Commissioner Fernandez Madrid, the ex-spouse of intervenor respondent Felix Madrid, who is owns property adjacent to the development, whether they were a relative under the applicable Oregon statutes. In order for an individual to be a relative when they are ex-spouses, there must exist a legal support obligation between the public official and the outside impacted party, and specifically the statute says for that outside individual. petitioner has submitted a motion to take additional evidence relating to the prior dissolution proceedings between intervener respondent and Commissioner Fernandez Madrid. But the only evidence that petitioner proposes to include indicate that there may be a support obligation from intervener respondent to Commissioner Fernandez Madrid, which is the opposite phrasing of the statute. It would need to be a legal obligation that Commissioner Fernandez Madrid held for intervener respondent in order for them to qualify as relatives under the Oregon statutes for conflict of interest. Recusal would only be required if the parties were relatives and there was an actual conflict of interest. In this case, it is at best a potential conflict of interest that should have been disclosed, but it is our position that there is no disclosure was required because there is no conflict of interest. So if this matter were to go back in front of the Planning Commission, it would be the respondent's argument that there is no conflict of interest that would require Commissioner Fernandez Madrid to not participate in that hearing. The 7th, 8th, and 9th assignments of error relate specifically to these applicable decision criteria. Specifically, the 7th assignment of error relates to the conditional use permit. There were multiple specifically cited instances where the application at issue here did not meet the criteria in the Carlton Development Code relating to site size and dimensions, that they must be suitable for the proposed use. Petitioner made arguments made statements, excuse me, on the record that they could only develop the property with 2 driveway accesses, which is not allowed under Carlton's Development Code for this parcel, and therefore the site size and dimensions are inadequate for the proposed development. And there were additional issues relating to the site design review, again, relating to that driveway spacing standard, and it was inappropriately requested to be modified under as a major modification of street standards under Carlton Development Code 17.64.050. So time is closing in. It is respondent's position that the petitioner's petition for review fails to allege that any substantive or substantial rights were impaired based on the procedural irregularities at the lower hearings, and the applicable criteria support a denial, and there is adequate evidence on the record supporting the city's denial of this application.
Thank you. And thank you for being mindful of your time. We just got to 15 minutes. Appreciate that. We'll return to petitioner for your rebuttal. You have 3.5 minutes for your rebuttal. Go ahead. And you're on mute, petitioner's counsel.
Thank you, Board Chair. So yes, we dispute as a factual matter that we weren't willing, or we did not offer a waiver of the 121-day deadline. We make citations to that point. He does acknowledge we requested de novo hearing. And again, even if his argument, or even if as a matter of fact, we didn't offer a waiver, that kind of comes to the crux of our position, which is you can't condition an applicant's substantial right to a full and fair hearing on a waiver of the 120-day deadline. ORS 227178 says you can't. We cited to that, I think, record 87 in our appeal statement. You can't do that. And that's kind of the crux of the whole thing. So, and yes, our statements were conditional because we were stuck in an on-record appeal hearing. So we were in a position where we were informing the city that, in our view, it would be legal error to deny the application if they didn't give us a de novo hearing or in request to submit evidence, or they could approve it, but it would be legal error if they had substantive issues to make the denial in that on-record review. They were aware they could cure these procedural issues that we alleged, but they chose not to, and they made a denial after the on-record review. So that also goes to the, as it relates to preservation, issues are different than arguments. The board is aware of that. The issue that the ORS 197-835-10AB remedy is intended to protect is an applicant's statutory rights to a full and fair hearing within the 120-day deadline. It's intended to add teeth to the 120-day deadline. That's what Miller v. Multnomah County say in the Walmart cases and other subsequent cases. So a bad faith denial means a denial, and this is discussed in the Walmart final opinion. A bad faith denial, it's kind of interesting language, but a bad faith denial means a denial not on the merits, and not on the merits means a denial which denied an applicant its substantial rights to a full and fair hearing. So we argued that issue below. It was preserved. We didn't cite the remedy, but that's not unusual because, petitioners below or applicants below aren't talking about, ORS 197-835-9C, substantial evidence, what have you. The substantive issue is that we were denied a full and fair hearing with because of concern with the 120-day deadline, and in particular mandamus in whole or part, which I think the respondent acknowledges that the mandamus was a factor in the decision. So as it relates to Councilor Terrell and bias, if the board reaches that assignment of error, I just, as a factual matter, I disagree that her disclosures were adequate. Again, part of the issue that applicant had in this case is we didn't have enough time to review things. And so I guess the board has a policy question of, are they going to require an applicant to, are you going to essentially reward an inadequate disclosure? Because it's a lot different to say, I signed a petition at some vague point in the past versus I signed a petition in opposition to this specific application, which opposed the application at this particular site. And in any event, we did, I guess by just stroke of luck, end up objecting anyways, which as a matter of preservation gave the city opportunity to cure and correct, which is the policy intent behind preservation, giving them opportunity to correct the error before an appeal. So, and then the city made a decision on a tainted record.
Okay, we've
Yep,
exceeded your time now, so was a
Thank
good
you,
place to
thank you,
stop.
Board Chair.
Yep, thank you. That will conclude oral argument. The statutory due date for our decision in this appeal is July 1st. We'll ask that the parties agree in advance that we issue our decision no later than July 22nd. Is that okay with these parties?
Yes, Board Chair.
Nods all around. Thank you. And thank you for your arguments today. And that will conclude our oral argument. Have a great rest of your day.